Right. Ms. Richards, are you able to hear me okay?
Yes, I am, Your Honor.
Okay. You had any contact with Mr. Blumberg? I don't see either him or his client
I have
present.
not since mediation. However, I don't think I received notice. It was just kind of a coincidence that I saw that the hearing was scheduled for today.
Okay. Right. Let me do some checking here real quick. If you can
Okay.
just remain on line and Ms. Vanderchob, you as well, and I'll be back in just a second here.
Thank you, Your Honor.
Okay, Ms. Richards, it sounds like Mr. Blumberg's in court in front of Judge Hesselink right now. So if you guys can just remain on the line, apparently his office said that as soon as he's done with that hearing, he'll sign in here. Um, and I did check the file. It looks like the notice was sent out back in June. So you're saying that you didn't get that notice back in June?
Yeah, and I looked in my file and I didn't see the notice. And because I was checking the court's docket for this day for a completely unrelated matter and just happened to see my name. Um, and usually when I get those notices, I put it in my file or put it in my calendar and immediately send it to the client. And noticed I hadn't done either of those things.
Okay.
So I don't know if it
Um,
got lost in the mail or,
It may have. I know that it went out because I've
yeah,
got it here showing that it was sent to you or mailed out to you on June 3rd. So yeah, if it didn't make it there, I'm not sure what would have happened in the middle.
yeah. And
But
I did confirm, I noticed it was both on the court's docket and on the case search.
okay. All right. So if you can just remain on the line here for a few minutes, and as soon as I see Mr. Blumberg, we'll get started with the hearing.
Sounds good. Thank you, Your Honor.
Thank you. Okay, Ms. Richards, I'm just going to ask you to remain on for a little bit longer. My assistant Jennifer is going to call over to Mr. Blumberg's office and just make sure that he is aware of the hearing today. And I'm going to take another case just here while we're waiting, but if you could just wait a little bit longer.
No problem. Thank you, Your Honor.
Thank you. Okay, I see Mr. and Ms. Morrison are both connected. We'll go on the record. This is file number 2419800. I'm sorry, wrong file number. This is Morrison versus Morrison, file number 2319363. The record should reflect both parties are present today by Zoom video. This is set for a status conference this morning. I did have a chance to look at the file, and it looks like there was a mediation that occurred just a few days ago, maybe a week ago, week and a half, and that there was an agreement that was able to be reached. Ms. Morrison, would you agree with that?
Sorry, yes, Your Honor.
Okay, and Mr. Morrison, would you agree with that as well?
Yes, Your Honor.
Okay, and I was looking at that mediation agreement. It looks like it also involved issues relating to custody and parenting time. I know there is a hearing that's set in September, later this month on September 24th regarding those issues, but based on your agreement, Ms. Morrison, is it your view that that hearing isn't needed anymore?
Absolutely, Your Honor.
Okay, and Mr. Morrison, do you agree with that as well?
I agree. Yes, we don't need that meeting.
Okay. All right. So what we have to do at this point now is, just because we've got an agreement, is just get the paperwork taken care of, and then I can schedule this for a hearing, a final hearing to finalize the divorce. I know you've both been waiting for a long time to do that, so I want to do that as soon as possible.
I appreciate you.
Yeah.
Thanks.
So what we need is two things. Number one is a judgment of divorce. That's the final thing that I sign to finalize the divorce. And then a final order from the friend of the court also regarding any child support. So Ms. Morrison, are those things that you think you can get taken care of in the next 30 days?
Absolutely, Your Honor.
Okay, so I will set this for a final hearing. It'll be by Zoom, just like we're doing today. I'll take the testimony that I need from both of you, and then we'll finalize the divorce. Ms. Morrison, do you have any questions about that?
So we'll have this next court scheduled. Does that mean that we can disregard our upcoming court hearing towards the end of the month for custody?
Yes. Yeah, I'm gonna let Court know, and I think probably Ms. Kraus and Ms. Spillane are both on the line, so they're hearing this. So yeah, because there's an agreement, you will not need to appear for that hearing on the 24th of September. My office will send you out another date for your hearing in front of me. And again, as long as you can get that judgment of divorce and the final order from friend of the court here to the clerk's office prior to that hearing date, then we can finalize everything and be done on that day.
Amazing. I appreciate you so much, Your Honor. Thank you.
Mr. Morrison, did you have any questions at all?
No, Your Honor.
Okay. All right. Thank you. That's all for today. And you're both free to disconnect at this time.
Thank you, Your Honor.
Okay, Mr. Blumberg, are you able to hear me okay?
I am, Judge. I apologize. I've in my third court already today, so
That's what Jennifer said.
I appreciate her passing that along. I been somewhat on edge here trying to do everything.
Okay, no problem. So we are on the record now in Vanderchob versus Vanderchob. This is file number 24-19800. We do have everybody connected now. And this was set for a status conference today. Ms. Richards, on behalf of plaintiff, can you tell me where things stand here?
So we had mediation a couple weeks ago. We were unable to get any issues resolved at mediation. At this point, I would ask that the court schedule this for a bench trial. I don't know if any more mediation would be beneficial. We also have a friend of the court hearing on child support coming up on October 1st.
Okay. All right. Thank you. Mr. Blumberg?
Judge, we're at a standstill because the mother has filed an objection to a child support recommendation. There is a rather significant arrearage once that matter is resolved. And that's relevant because the only really remaining issue is the marital home and how the equity is to be divided. Unfortunately, our hearing in front of referee legal is not until October. So we can't resolve that without getting a ruling unless that's something you might want to undertake, perhaps not. But that's really the impediment to resolving this case.
Okay. It sounds like if we do have some kind of evidentiary hearing or bench trial regarding the division of assets or debts, that it would be a fairly limited issues that the court would need to decide. Ms. Richards, is that?
That is correct, Your Honor. Mr. Blumberg is correct that we still have the child support. However, it's mine and my client's opinion that the child support hearing is not going to have an effect on the division of assets and debts. And as Mr. Blumberg stated, really the only asset is the marital home.
Okay. So I guess my thought would be to, just so that we can keep things moving in the case and recognizing that hearing in the front of the court, did you say October 2nd?
October
Actually,
1st.
First, okay, sorry.
October 1st. Okay. So if I were to set this for, just to be cautious, a half a day evidentiary hearing on marital assets and debts for 60 days out. That way, if, the child support issue does or doesn't resolve anything, then we'll have that date and the parties can still move forward without having a delay. Mr. Blumberg, do you have any objection to that?
No, I don't have any objection.
Okay, Ms. Richards, do you have any objection to that?
No, Your Honor.
Okay, so we'll set this for a half a day hearing at about 60 days out. For my usual, I'll put in the scheduling order that the parties are to submit 7 days prior to that date, trial briefs. And what I'm really just looking for is your proposed division, each of your proposed division of assets there, and what you think the significant factors are, just so that I have some idea before the hearing on what you're both going to be asking for. And that's how we'll go forward. Ms. Richards, anything else I can address for your side today?
No, Your Honor. Thank you.
Mr. Blumberg?
No, Judge, thanks.
Okay. All right, and so I'll put that into the order, get that date out to the parties. And Mr. Blumberg, I think you have the 9:30, so I'm just going to put you on hold for a minute, and then we'll get started with that hearing at 9:30. Ms. Richards and Ms. Vanderchob, you're free to disconnect at this time. Thanks for your patience this morning.
Thank you.
Thank you, Your Honor.
Okay. All right. See you later.
see that Haskell file.
Yes.
Okay, whoever's on the phone with the last four digits of 2814, can you tell me your name, please?
Ty Gatewood Cotton.
Mr. Cobb. Okay, I'm just gonna put you on hold. We have one case we have to take before yours, and then I'll bring you back in.
Okay, sir.
Not there for them, but, and I said it would be best for the kids if she reached out and called. Reiterated that on Tuesday.
Okay. Let's see. All right, we have both counsel connected. We'll go on the record in Haskell versus Haskell. This is file number 2218880. If I could have both counsel put your appearances on, please.
Zach Backlund on behalf of the plaintiff, Aubrey Haskell, Your Honor, who's also appearing by Zoom.
Good morning again, Judge Elliott Blumberg on behalf of David Haskell.
Okay, this is set as a status conference today. I know we've been kind of waiting on child support issues in friend of the court. And so Mr. Blumberg, or I'm sorry, Mr. Backlund, on behalf of plaintiff, can you tell me the current status and what you would like to request going forward here today?
Certainly, Your Honor. So we now have a child support order in place. So we can calculate the arrears as of now, which I know is part of the issue is how much would those arrears be? or would Mr. Haskell be receiving any credit toward those arrears? I went back in my notes. I know we had a trial on this matter way back at the end of 2023. And during that time, we put on the record that the parenting time would be equal. And so a support order would be effective for the 182.5 overnights after January 1st of 2024, I believe. And so at a friend of the court hearing, it looks at back in April of 24, and I may need to go back and review the record, but my notes indicated that we had agreed the $300 per week in child support would be effective through that trial date, which was the end of December of 23. And then the new support would be effective after that time. And so my rough math, if that was correct, would be about 16,000 total in arrears going back to February of 23. Of course, I know we have some statements going back and forth, literally statements, bank statements, and things of that nature, where we were putting our notes and submitting figures that we thought would be credit. We may need to come back in because I know Mr. Haskell has asked for credit toward the child support and the spousal support. So we need to figure out what he's going to get credit for, if anything.
So kind of a continuation of an evidentiary hearing that we had started previously.
That's correct, Your Honor. And there is another hearing set on the front of the court side of things for the arrears. So I'm wondering if the court or the front of the court would like us to consolidate that into one if you're able to calculate the child support and the spousal support arrears, Your Honor.
Okay, thank you. Mr. Blumberg?
I think that those statements are correct. This has been a long and winding road for sure in this case. And I don't know whether Mr. Backlund and I could sit down with Ms. Krause or somebody from the front of the court and try to work this out ourselves without taking up the court's time. I would certainly offer my client and myself available to do that if Mr. Backlund saw that to be a worthwhile endeavor.
I would.
Is that something?
I would. Yeah, I would try.
Okay. All right. Is that something that, because I think Mr. Blumberg, the next hearing is set on September 24th. Is that something that you guys could try to do on that date, since that's already a date that's on the calendar, or would you like to try and schedule a separate date?
And is that in front of referee legal? Because I think all we need is a representative from the front of the court, because I know his dockets are pretty busy, and it might be beneficial if we could sit down with somebody else within the department.
Okay. Ms. Krause, can you speak to that?
The hearing is set in front of the referee for that date for the direct payment credit. I guess if the parties want to submit the information, that way we have a scenario of what we could potentially see as that is, because the court may potentially need to order us to do something specific. So I don't think it would be a bad idea at least to have that hearing if that's the case.
And would you be available on that day to meet with the parties as well?
Prior to the hearing time?
Yeah.
Let me look to see what time it is, because that's a normal referee day and usually I have to be available for court, but give me just a moment.
Okay.
Your Honor, I do also have other cases that I would be needed to be present for. So I believe if maybe potentially the information could just be submitted in a short amount of time to review. If there's questions, maybe I could reach out and we could even possibly set up some sort of a Zoom conference that would work. Potentially even maybe Edward could sit in on it, or Dawn, who would be able to give some scenarios of what would be needed, so we could just present possibly something to the court.
Okay. Mr. Backlund, does that sound okay?
That sounds okay to me, Your Honor. Yeah.
Okay, Mr. Blumberg?
Sure, that's fine.
Okay, so then what I'll do is I'll just set this for another status conference in October, and then we can check in and see what the parties were able to accomplish and go from there. Mr. Backlund, anything else I can address for your side today?
The only thing I would ask, I know we're talking about support in the arrears and so on and so forth, and whether there's going to be credit for any, is the expectation. I would hope that the support would be paid on a monthly basis, going forward. I know we're looking back toward arrears, but I know there is spousal support and child support that's meant to be paid. I know there's no order regarding the spousal support, but the court, has found previously that the support in the parties' agreement is appropriate. Is the expectation that will continue to be paid on a monthly basis going forward, or are we waiting until we figure out the credit?
Mr. Blumberg?
I wish I knew the answer to that. I mean, I don't.
Well,
Go ahead, Judge. Go ahead.
Well, my thought is if we have a child support order that's in place that hasn't been objected to, then that should be, that's the order of the court that the party should be following going forward. To the extent we have to address things that have happened, like you said, Mr. Blumberg, in the past, we still need to work that part out. But going forward, the child support, at least, I think if there's an order with no pending objection, then that should be effective. In terms of spousal support, if we don't have an order in place for that, I don't think I would have a basis to require Mr. Blumberg's client to start paying that. It may be, if that's something that's gonna be in place eventually, it may be in his best interest to do that. But I think in terms of the court requiring something, I think I would be limited to things that are actually orders of the court at the present time.
Fair enough. Understood. Thank you.
Okay, thank you. That's all for this hearing, and the parties are free to disconnect. Mr. Blumberg, I think you have a 10 o'clock, so you can sign out if you want, or I can just put you in the waiting room.
Judge, I'm sorry. I hate to impose on the court. Apparently, I have another hearing in another court. The Ferris matter is a status conference. Mrs. Ferris is unrepresented. There's still matters pending before the referee. There has been an objection filed in that matter. Is that coming to you or to Judge Hesselink? Do you know?
I believe the objection is going to be coming to me, so I would just be setting that for a hearing today. Do you know how much time you're going to be asking for a hearing in that?
Probably an hour and a half to 2 hours.
Okay.
Yeah.
So I can address that with Ms. Ferris on the record at 10 o'clock if you're not able to sign in.
Okay, I will try to get back as soon as I can.
Okay. Okay, sounds good. Thank you.
Okay, thank you.
Your Honor,
Yes.
just for clarifications, you're indicating that the Ferris file will be called at 10 a.m., not 9?
Right. We kind of had, it was set for a status conference at 9 and then a hearing on the objection at 10.
No worries. I
So-
just wanted to make sure I would be available and I wasn't sure if it was removed. Thank you for that clarification.
Yep, no problem. Thank you. Okay, we have all the parties connected. We'll go on the record in Cotton versus Cotton. This is file number 2319201. If I could have counsel put your appearances on.
Good morning, Your Honor. Jennifer Dusenkoy on behalf of Keela Cotton, who is present with me in my office.
Good morning, Your Honor. Katie Komorowski on behalf of Ty Cotton, who is present on Zoom via telephone.
All right, thank you. We're on the record today for a status conference in this matter. On behalf of plaintiff, Ms. Dukes-McCoy, can you tell me where things are at since our last hearing and what you would like to request going forward?
Well, at this point, Your Honor, the parties have resolved everything. Anything that they couldn't resolve was resolved by the court. I had revised our judgment of divorce. And then I had gotten approval on that and the party's uniform child support order from the front of the court last week. I had sent that over to Ms. Komorowski and I hadn't heard back. So we're prepared to enter documents to get the divorce finalized whenever we hear back. I wasn't sure at this point if we required consent from all the parties or if we could just submit documents to the court directly for signature.
All right, Ms. Komorowski?
I apologize, I missed that email, Jennifer. I will review that and get back to you, but I also have a similar concern, considering parties agree to a large portion of the judgment, but other portions were decided by the court.
Have we taken proofs in this case yet?
We did, but that was back in October of 2023 or November.
I believe it was
Okay.
November 2nd, 2023.
All right, so I don't think we would need to take statutory proofs again. I think it would be maybe good to nevertheless schedule this for a final hearing once all the documents have been prepared and everybody's had a chance to review them, so that we can supplement the proofs, I think, with new developments and findings of the court, so that we have a very clear record. Do you have any objection to that, Ms. Dukes-McCoy?
No, I don't think so, Your Honor. Hopefully that could be soon, maybe at the court's next motion hearing date, so.
Ms. Komorowski, any objection to that?
No objection. I agree with Ms. Dukes-McCoy. We could do that at the next court's motion hearing.
Okay, so I will set this for a final hearing at my next available date. The court will send out notice of the date and time of that hearing to all parties, and we'll finalize things at that time. Ms. Dukes-McCoy, anything else I can address for your side while we're on the record today?
Just my client and I were talking about a problem that, not really a problem, but I just wanted to point out to Ms. Komorowski and Mr. Cotton. The parties are following the 46th Circuit Court standard parenting time schedule for holidays, and I think there's two different versions online. The one that my client has and that she's provided to Mr. Cotton is the one that was revised by the court in December of 2022. And I think it's on the Crawford County site, but I don't think it's on the Otsego County site. Anyway, I just wanted to be clear that that's what we're to be following, and so that there's not confusion between the parties, since we just had a holiday, which is Labor Day, so.
Okay, Ms. Komorowski, is there any, I believe the party should be, if you've agreed to follow the standard holiday parenting time schedule, then it would be the most recent one that the court has implemented. Do you have any issue with that, Ms. Komorowski?
I do, because my client believes that he was supposed to have this Labor Day weekend, and then the plaintiff wanted the child to be returned by 6 p.m. He returned the child, then he re-reviewed the documents he had, and then according to the documents that he had at the time, believed that it was his weekend, so he went back and picked the child up. The plaintiff wasn't even home.
All right, well,
And
going forward.
there's a dispute, Your Honor, about which one this is, because this is an odd year, and I'm looking at the one that was revised in 2022, and it's very unclear because it says under co-parent parent B, odd number years, it says Labor Day weekend, that the parent B should have the child through 6 p.m. on Labor Day, Monday. And in the past, plaintiff's attorney, Ms. Dukes-McCoy, has indicated to me that her client is parent A and my client is parent B. So even according to this, Your Honor, the way I'm reading it, unless I'm reading it wrong, please correct me if I'm wrong, but if I'm reading this correctly, my client should have had his son through 6 p.m. on Monday.
Right. Yeah, we agree with that, but Mr. Cotton, I think, was going by the old one, which said 8 o'clock on Labor Day, and so the time was just different. I don't think there was any more of a dispute than that.
Right,
He was
we're
telling me
talking
that
about-
she wanted,
Oh, go ahead.
my client told me this morning that the plaintiff had wanted the child returned on Sunday at 6. And I may have misunderstood that, I'm not sure, but that was my understanding.
I don't have that parenting time order in front of me, and so I can't look at it and see exactly what it says, but I'm just waiting. It looks like Miss Duesman is talking to her client here. I want to hear what she's got to say.
Well, I think the confusion was over Labor Day weekend when it ended. And my understanding is the defendant brought him back early, the party's son early, thinking that it ended earlier. He did end up getting most of Labor Day after the parties had a discussion about it. And then, anyway, so there was confusion, but that's all that I wanted to say about that particular issue. I think I'll attach the schedule to the party's judgment so that there's not confusion, so that they know which document we're referring to, and then that could be referred to easily by the parties if a question does come up. I did say previously that, and it says in the party's judgment that Mr. Cotton is parent B, so I don't think there's any dispute as to that, which I had heard Ms. Komorowski mention. So in any case, I think that that's something that the parties hopefully can be able to work out going forward.
Okay. All right, so the court will set up that final hearing date. We'll go forward at that time, and all parties on this case are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Good day, Your Honor.
Thank you. Okay, next hearing's at 10 o'clock. We'll take a short recess until cases. All right, we'll go on record in Ferris versus Ferris, case number 2419904. Neither party appeared for that hearing. However, Mr. Blumberg, who is attorney for plaintiff, did notify the court during a prior hearing this morning that he had a conflict with another hearing at 10 o'clock in a different court. So in that case, there is an objection that was filed by the plaintiff to a recommended order by the referee as to a parenting time violation. So the court's going to set that for a 2-hour evidentiary hearing within the next 60 days, and then set this for a status conference at the same time as that hearing to determine how to go forward. And then 2 files that were set for 10/15. We have Jeff Hodges versus Matthew Kassar, file number 2520182. Jeff Hodges versus Andrew McCune, file number 252120183. Both of those were set for in-person hearings on petitioner's motion for PPL in both of those files. Again, that was set for 10/15. It's now 10/23. The petitioner has not appeared. The court notes from the file that the petitioner did not provide any proof of service. So at least based on the information that I have at this time, the petitioner did not serve either of the respondents. So the court does not find any fault in the respondent's failure to appear because they likely were not aware of the hearings. However, because the petitioner did not appear today, court is going to dismiss his motions for personal protection orders in both cases because of his failure to appear. Our next hearing is set for 11/15. We'll be in recess until that time. All right, we have everybody connected, so we'll go on the record in Meyer versus Meyer. This is file number 2419940. If I could have both counsel put your appearances on.
Good morning, Judge Elliott Blumberg on behalf of Melinda Meyer.
Good morning, Your Honor. Travis Grote on behalf of the defendant, Alexander Meyer.
All right, thank you. We're on the record today. I have it set as a status conference / final hearing. Mr. Blumberg, can you tell me where things are at with this file, please?
Sure, Judge. I can represent to the court that the parties have, in fact, agreed on all issues. I was hoping to be able to take the proofs from my client today. I don't see her, so I am in the process of drafting a consent judgment divorce, sending that over to Mr. Grote for his review and signature.
Okay, thank you. Mr. Grote?
I would agree, Your Honor. The parties provided us with a fairly lengthy 14-page agreement that they are wanting us to put together into a judgment. We've gone back and forth a bit on it, and I believe that the parties are in agreement at this point. We're just needing a bit more time to finalize the judgment.
Okay, so I'll set it for a final hearing then to take proofs. Mr. Blumberg, anything else I can address for your side today?
No, Judge. Thank you. Though, before we sign off, could I just have a moment of your time when this case is completed? I have yet another conflict at 1:30, so.
Okay, yeah, certainly. Mr. Grote, anything further that you needed to address?
No, Your Honor. Have a good day. Take care, Elliot.
Yeah, thanks, Travis.
Okay, thank you. And then Mr. Blumberg, as to the 1:30?
The Trevor case, I'm going to be a bit late. I have another 1:30 in Emmett County that through Zoom, so I will get back as quickly as I can.
Okay, I actually have two 1:30, so I'll just take the other one first, so that'll create a little bit of wiggle room there. So
thank you. I appreciate it. Thanks again.
We won't go forward without you.
Okay. Sometimes better to do that, though. See you later.
Okay, thank you.
Yep.
All right, looks like we have everybody connected, so we'll go on the record in the matter of the Korn Family Limited Partnership. This is Charlevoix, file number 031723-19-CB. As usual, I'm sitting on this case by assignment from Charlevoix County. This hearing's taking place here today by Zoom in Otsego County. And let's see, in terms of appearances, we have Mr. Finling here present as a receiver by Zoom. Mr. Schur is here on behalf of Shauna Korn. I see Mr. Smith is present on behalf of Homer McClarty, and who is the Chapter 7 trustee of Gail Korn. We have Mr. Nelson present on behalf of the trustee for Sheldon Korn. We have Mr. Cleavorn present on behalf of Ashley Byron Korn. And I think that's everybody. So we're on the record here today for purposes of a status conference, and then Mr. Finling did file a motion regarding the overpayment, and I think, Mr. Finling, I'm sure you'll explain that. Oh, go ahead.
I just want to indicate for the record that Mr. Bullock, who represents Larry Lenchner, will not be appearing, and he's already consented to the relief that I've requested.
Okay, all right, thank you. And your motion, Mr. Finling, is essentially just to establish the amount of the overpayment, is that correct?
The amount and then permitting enforcement, Your Honor.
Okay. And the other parties may have filed some type of response. If they did, I didn't see it or get a judge's copy, but I guess I'll just throw this out to the other attorneys. Mr. Sheriff, if you want to start, do you have any opposition to that motion?
So just quickly, first, just so the record is clear, in addition to representing Shauna Korn, I also represent Sheldon and Gail Korn. There are some issues relating to this motion on the overpayment, and it really goes to the form of the order / judgment that the court is going to enter. And Mr. Finling circulated a proposed order to the parties on this call last week, and Dean Nelson, after having some discussions with me, sent an email to Mr. Finling raising, I think, probably about 4 different issues about things he was concerned about in the proposed order judgment. Had to do with things like having there be judgment language, not just be an order, because there's certain types of collection action I think you can only take with a judgment as opposed to an order. We had wanted the judgment to be joint and several against all the plaintiffs. Instead of just Mr. Lenchner, it was his entities who had also gotten a $2 million judgment to begin with. We wanted there to be interest accruing from the date or dates of the overpayments. And I think there was also some issue about some reservation of rights language in that order / judgment. I saw on Friday, Mr. Finling sent an email back to Dean responding to each of those 4 inquiries, and seemed like he didn't have a problem with any of them. He apparently sent the proposed order judgment to Mr. Bullock at like 9:30 or 10 o'clock this morning. Mr. Bullock wrote back and said approved, meaning I guess he stipulated you could sign off on his name. The only issue is that he said approved to the form that Mr. Finling circulated to us last week, and didn't address the concerns raised in Dean's email that we thought he was going to address, because he emailed back on Friday and seemed to be okay with all of the changes. So that's where that stands.
Okay. Mr. Nelson?
That is accurate. The only other comment or point that was raised was, it might be nothing, but who exactly is the judgment in favor of, whether it's KFLP as the entity in receivership versus Mr. Finling as the receiver of the receivership. And the only issue is we're not clear if this judgment is going to survive the receivership, at which point, how does KFLP enforce it if it has to, when it's in the name of the receivership? And maybe that's not an issue, but unfortunately, that particular issue had not been resolved. It was the only one that Mr. Finling did not, I guess, agree with. But otherwise, it was our, or my impression anyway, that he was going to take our concerns into consideration and circulate that to Mr. Bullock. And it's not clear that that happened.
All right, Mr. Smith or Mr. Claiborne, do either of you have any input?
No, nothing further. Your Honor, Kevin Smith. I would agree with Mr. Nelson and Mr. Scheer that if we can get the revised language, I would certainly sign off on that.
Yeah, and I don't have anything to add that hasn't already been said, Your Honor.
Okay, Mr. Finling.
Your Honor, first, MCR 7.202 only permits one final judgment order in a case. So the document is entitled an order, which is enforceable as a money judgment. So semantics aside, whether it's called a judgment or an order, it's still enforceable based on its language, not on its title. Second, the proposed order that I circulated to the attorneys does provide for judgment interest. I don't know why Mr. Scheer didn't reference that in his comments, because it is in there. Next, with respect to joint and several, I have no objection to that, but there's a problem. The entities of which they're describing with respect to joint and several have been defunct for 10 to 15 years. If they want, for the purpose of including additional entities that are dissolved automatically by DLEG, do not exist, are not in operation, are outside the time for any type of voidable transfer claim, I have no objection to that. I thought it was not worthy of the effort. Next, with respect to the judgment being for the benefit of KFLP, I'm frankly surprised that a number of bankruptcy attorneys are suggesting that a judgment be in the name of the party rather than the estate. The overpayment was made by the receivership estate, no different than a bankruptcy estate. The judgment is in favor of the receivership estate, not KFLP. The purpose of including the reference to the receivership estate is because as the receiver of the receivership estate, I would be seeking to recover those funds on behalf of the receivership estate. At some point, the receivership estate will no longer exist, and the court will direct that any monies that are in the receivership estate go to the person or parties that are entitled to those funds. There is no reason, that the judgment has to say in advance, or whatever the court may do, that the funds will be paid to KFLP, because right now they're not owed to KFLP. They're owed to the receivership estate. So the motion was filed by the receiver on behalf of the receivership estate. It was not filed on behalf of KFLP. If the attorneys want a separate order that says at some point, depending on what the court may do, that the receiver will assign whatever it may be in the future to KFLP, I don't know that that makes or helps in any way. Right now, I'm a fiduciary on behalf of an estate. I am not KFLP. KFLP is not entitled to this recovery. The receivership estate is. And then when the receivership estate is dissolved, if those funds go to KFLP, that's what the court will order. But I'm perplexed by the idea that somehow a judgment is being entered on behalf of KFLP when first, the relief that was sought was not sought on behalf of KFLP. And second, the recovery doesn't inure to the benefit of KFLP, it inures to the benefit of the receivership estate. So all these arguments are well taken, but they're not how things operate in a receivership. The receivership overpaid money to Mr. Bullock's client. The receivership is seeking to recover that money for the receivership estate. Those who benefit from the receivership estate will be the ultimate beneficiaries of whatever that recovery is. But it makes no sense to include in the judgment that somehow it belongs to KFLP, because it doesn't. The court determines when monies are paid to KFLP, or in this case, these various members of KFLP. So I've done my best in scrivening to both draft appropriately the relief that would be sought. Secondly, that I responded to Mr. Nelson with each of these comments. I don't know that it is going to somehow change things if we call it a judgment or an order. Frankly, I don't think it's a misnomer, but I'll answer any other questions the court may have. I think the order, and one last thing, the question was whether or not I would remain liable in the instance where I am not able to recover money or property, and that the order should provide for that. Well, if it says that it's without prejudice to whether there's a recovery against me, or it omits that, doesn't change the deck chairs at all, because everybody knows, including myself, that there's a claim out there for the possibility that I may be liable for the overpayment. And the fact that it's in the order or not in the order doesn't change anything. Nobody's waiving or putting any prejudice on any potential recovery against me as the receiver. And whether the order says so or not, again, is a lot of lawyers trying to put in their comments, but it doesn't have any weight of law, whether it's there or not. So I'll answer any other questions the court may have, but I think that the order that I drafted is completely appropriate, consistent with the terms of what the relief that I've sought. And I don't know that any of the arguments that are being made somehow will change the substance of the relief, which is the receivership estate has sought to recover this money. The receivership estate is seeking an order which says that Mr. Lenchner is indebted to the receivership estate for these monies. The monies were paid to him. The checks were written to him, not to these other entities. But again, if the court wishes to rule differently or direct that the order provide differently, I'm perfectly willing to accommodate or obviously respond to the court's concerns. But I don't know how this is helping anything other than focusing on me recovering money from Mr. Lenchner for the benefit of the estate, which ultimately inures to the benefit of all these attorneys' clients. Thank you, Your Honor.
Your Honor, may I be heard again?
Sure.
Let me just make sure we're all on the same page and figure out how best to proceed. So I don't think anybody has any issue about whether the piece of paper is called order like it is, or is called judgment, because Mr. Findling does now have language in that says a judgment is entered. So I don't think anybody has an issue with that. The joint and several with the other parties, I know because Mr. Bullock called me this morning, he has no objection to having it be joint and several and have all those entities in. Mr. Findling has no objection to it. So I don't see any reason why we just wouldn't have it be joint and several against everybody. That takes care of that issue. The interest issue is an issue because Mr. Findling says it is further hereby ordered that the sums ordered paid under this order shall accrue statutory interest pursuant to MCL section 600.6013. The issue we have is just when does the interest start to accrue? And what we had suggested was that the interest start to accrue from the date or dates of the overpayments that comprise the 150,000 plus. And I don't know whether Mr. Bullock has an issue or not with that. I guess my suggestion is we just put it in the way we want it. And if he has an objection, we'll see whether we can resolve that.
So your question on that is whether the interest would start accruing On the date of the overpayment or on the date that the court signs the order?
Yes, or maybe even somewhere in between. It could theoretically, I guess, even be on the date that I filed Shauna's motion that related to the overpayment and was seek. So it'd be one of those 3 dates, but it's not clear from the order that Mr. Finling prepared and Mr. Bullock approved. It just says that sums ordered paid shall accrue statutory interest. Doesn't say from when. So until we send that to Mr. Bullock and see if he has an issue, that issue might be left for the parties to work out or the court to decide. The reservation issue that Mr. Finling talked about, I don't disagree with him that either he does or doesn't have liability for the overpayment if he doesn't get it back. But Dean Nelson had asked for some reservation language, and David on Friday said, I don't think you need it, but I'm okay with it. So if somebody wanted to put in and nobody has an objection to it, I don't see any harm in putting it in. And the last issue was, you know, who the judgment is in favor of. And the way that Mr. Finling has written it, it says that the judgment is entered in favor of the receivership estate, which isn't a defined term, but I guess the concern that we had, you know, I wanted this, I wanted candidly Mr. Finling removed and this estate closed a while ago. You know, we have somebody in there who we now have issues about unfiled tax returns and potential penalties. We have an issue about an overpayment that was made on his watch that shouldn't have been made. That's now creating more legal work and more time to keep this open. But the long and the short of it is, I don't think anybody has a dispute that he acts on behalf of Korn Family Limited Partnership. That's what he was appointed for to begin with, was to collect on the judgment, which he's now overpaid. And that overpayment was clearly something that's an asset that belongs to Korn Family Limited Partnership. He may be the guy acting on behalf of it as the receiver, but if the estate closes, we just want it to be clear that if it closes at a time where this judgment hasn't been paid, that KFLP will have the ability to enforce that judgment. Mr. Finling, when he was just talking to the court, kept talking about, I wrote it down, monies in the estate and funds in the estate. And I get where the money and the funds will then belong to KFLP, I guess, when it closes. We just want to make sure that the judgment, to the extent it hasn't been collected yet, will be an asset that KFLP can pursue. And I can't imagine anybody has an issue with that. And I'm sure can just put language in this thing that makes it clear. Could even add language that just says, if we left it, that it's an asset being pursued by the receiver, if and when the receivership closes, to the extent the judgment's still out there, then it'll belong to KFLP. I can't imagine anybody would have a problem with that. And so it seems to me the only issue would be the issue on when the interest starts to accrue. And we should just write it the way we want, send it back to Mr. Bullock. If he has a problem, we'll either work it out or I guess somehow raise that one issue for the court to decide.
Okay, Mr. Finling, did you want to add something there?
Well, I just want to make sure I understand. So it sounded like Mr. Scheer is saying it's okay the way it's written with the receivership estate. If not, let me explain the problem. So MCR 2.622A defines the receivership estate. Second, I was appointed for a specific purpose. I was appointed for the purpose of enforcing the judgment against KFLP in favor of Larry Lenchner. That is not what is going to take place here. So if it's for KFLP, I've got a problem because I don't have authority to recover this money under the terms of the order appointing receiver, because I was appointed for a specific purpose to recover the judgment against KFLP for the benefit of Larry Lenchner. So either we amend the order appointing receiver to address the concern of everybody, which is that I am now seeking appointed for the purpose of enforcing this judgment, which belongs to KFLP, or more appropriately, I continue as the receiver to enforce the orders of the court, and one of the orders of the court is the recovery of this money. I'm not certain where all this lies because, frankly, in the end, the court is going to discharge me. Everybody is going to have an opportunity to address any concerns in the future. So any money that comes in has to be accounted for. Any money that comes in that is rightfully belongs to KFLP or its members will have to be addressed by the court. So I'm not certain if Mr. Scheer is still addressing this question of the receivership estate or KFLP. But in the end, the estate was created when I was appointed as a receiver. The monies were paid out by the receivership estate. They should be recovered by the receivership estate. And then the court will direct whatever monies are recovered, whether it's from Mr. Lencher or from me. In any event, it goes into the receivership estate, and then it's distributed no differently than in every bankruptcy, which is the money goes into the estate, then there are claims, and those monies are paid out. So with respect to joint and several, I no objection. I thought that was superfluous, but I certainly don't have a problem with it. If the court, I'm fine with the question of what Mr. Scheer said about revising the language to address interest and the date of accrual. I'm fine with that. And then finally, I do remain staunch in my position that the recovery belongs to the receivership estate because the disbursement was made by the receivership estate, and then whatever is in the receivership estate is subject to a future hearing and disposition by this court. I'll answer any other questions the court may have.
All right, I just have a question, and maybe Mr. Scheer wants to address it. My question is this, Mr. Scheer, if the court were to enter the order with language that it's in favor of the receivership estate, or however we want to term that, when the court finally does close that estate, I mean, if that amount of the overpayment hasn't been collected at that point, as part of the final orders closing the estate, can the court insert language at that time? Because then we'll know whether some or all of that has been recovered, preserving KFLP's right at that time to pursue collection of any unpaid amounts of that.
Long as the court can do it, then, I mean, that's fine too. I just don't see the harm in putting, I'm happy to leave in the language that says the receivership estate or the receiver will pursue it. Could even put language in now in a footnote or someone else. It just says at the time, if the receivership is closed later and there's an amount owing, then KFLP will be the one withstanding to pursue it. I mean, I don't know anybody would have a problem with that. I mean, I agree that he can go pursue it. He talks about he was appointed to collect the judgment. That's done. He's still doing other things. He's still receiving all the distributions in the KFLP from these 5 apartment complex LLCs. So he is still doing other things. I don't know why he's confusing things with what he's doing or can do or can't do, but I'm happy to say he can collect it. It's a judgment in favor of him. And if your honor decides to leave that to the back end, I'm sure we'll clean it up. I just don't see the harm in saying something now that just says, to be clear, you know, to the extent the judgment is still outstanding, if and when the receivership closed, the judgment will belong to KFLP.
Your Honor, I have a problem. There's one thing that isn't being addressed, which is, what if there are liabilities for taxes? What if there is monies that have to be distributed other than to KFLP? All that comes in the future. So I can't change what may happen. And I certainly don't want the court to bind itself on saying that KFLP will get this money or this judgment when maybe it won't. So there's nothing other than comfort by Mr. Scheer. There is no benefit to anybody to include dispositional language in the order when we don't know the disposition today. It's what the hope for outcome is for Mr. Scheer, but it is not necessarily what will be the outcome. So I don't see any benefit of binding anybody to what will happen, because that's what will happen when it happens. It just doesn't have to be today. There's nothing that's accomplished by saying it will go to KFLP. It will be assigned. The court will make that decision when you discharge me. I have a bond. I have to get discharged. The court has to make a disposition of the property in the estate. It may be more, it may be less. I may have recovered other monies. All of that gets taken care of in the wash at the end, Your Honor.
All right. In terms of the, Mr. Scheer, have you and the other attorneys discussed when, in looking at the interest issue, which of those 3 dates that
I mean,
the
obviously,
attorneys?
it's in our best interest from the date of the overpayment.
Right.
I don't think anybody on this Zoom call has any issue with that.
All right.
Whether
Mr. Bullock will, I don't know, because it hasn't been run past him yet.
I'll simply, Your Honor, I'll simply revise the order, send it around to counsel, make sure that it has their approval. I'll resend it to Mr. Bullock, indicating that this is the consensus of counsel, not necessarily the court, and we'll get his input and we'll proceed from there. I think everybody's in agreement with respect to the accrual of interest and the desire that it accrues from the date of the overpayment. So with everybody's blessing, I'll do exactly what Mr. Scheer is suggesting.
All right, so that really just leaves the one issue then. And so, you know, I guess what I would ask, once we have an order incorporating all the other provisions that we've talked about today, what I would like to see, because I haven't seen, you know, Mr. Scheer, what you or the other attorneys would propose, the exact language and how that would read. So I guess that what I would like is once Mr. Findling has prepared the final order incorporating the changes that everybody agrees to and his language regarding who it should be in favor of, if you or any of the other counsel still disagrees with that language, then I would ask for you or one of the other attorneys to prepare the language that you would like to see. Mr. Findling, if you can submit your final language, Mr. Scheer or Mr. Nelson or Mr. Smith or Mr. Cleburne, whoever wants to do it, submit your agreed upon final language. And then, because I would really like to see how it reads, I think that would help me make a determination whether I think there's true legal significance to either one. And then the court will enter the one that it finds to be appropriate. I think you've all had an opportunity to tell me what your view is, and I think I understand where each of you is coming from here. So let's do that. Is that something that we can do in the next 30 days, Mr. Findling?
We can do it within a week, Your Honor.
Okay, even better. I'll give you 30 days just in case.
Your Honor, is it possible I can say one more thing?
Yeah, of course.
And I apologize for going back to this, but Mr. Findling, at least on the record today that I remember, didn't acknowledge whether or not he's willing to put in the reservation language that the judgment against Mr. Lenchner and the companies is without prejudice to the ability of the KFLP or the receivership estate to go after him for the unpaid amount. And the reason I view this as significant is this started with Mr. Scheer's motion where he sought those two requests for relief, a judgment against Mr. Lenchner and a judgment against the receiver. And as I view this, if that is viewed as the complaint and this judgment is being entered presumably as a final order, that leaves the claims against Mr. Findling dangling out there unresolved. And so I do believe this needs to be put in this order that it's without prejudice to those claims, and it's not added language that we're asking for. I actually view there may be a claim preclusion issue if it's not. And so that is why I asked for that. And again, Mr. Findling in his email indicated he had no objection, but at least on the record today, I don't believe he acknowledged that.
All right, Mr. Finling, is that, do you have an objection to that language? I know you said you don't think it's necessary, but do you have an objection to it being in there?
Yeah, so let me address the why and then the answer. First, Mr. Nelson is mistaken with respect to claim preclusion because there's only one final order of judgment under the rules for final judgments under 7.202 subparagraph 6, I believe it is. Having said that, to the extent it creates a concern, I'm not going to be an obstacle to saying it's without reservation because it is without reservation. So if it needs to say it and makes everybody feel better that it's in there, no objection, Your Honor.
Okay, all right, great. Okay, so let's go forward as I've indicated within the next 30 days. If there's still a disagreement with regard to the language between KFLP and the receivership estate, that each side will submit their proposed language. The court will enter the order it finds to be appropriate based on the specific language that's submitted. So I think that takes care of that issue. Aside from that motion, we were just set for just a general status conference to see where things were at with the other aspects of the case. And so I just want to know where counsel wants to go from here, what I need to do scheduling going forward, or what you would all like to request so that we can keep this moving towards final resolution. And I don't know who wants to jump in first. I'll leave it open to you guys.
I'm happy to, Your Honor. So,
okay.
Court may recall the biggest immediate issue was dealing with the unfiled KFLP tax returns from like 2007 all the way forward. So John Bull did get retained. The bankruptcy court was okay with that because he's also the accountant for the two trustees. So Mr. Bull has been putting the tax returns together. Your Honor entered at least one order or more that had to do with the procedure to go through to get the tax returns filed. Mr. Bull has done a Herculean effort, has put all the tax returns, all of them together, has circulated them out. They went to Mr. Finling for informational purposes, but he didn't have the ability to comment on them. All the other parties did. And so everybody, with the exception of Ashley Byron, Mr. Cleavorn's client, has communicated that we're all good with those tax returns. Mr. Cleavorn has communicated with us and said he hasn't raised any objections, but is still waiting to get the thumbs up from his client that she doesn't have any issues with the returns. The hope is that she will give the green light to Mr. Cleavorn imminently, in which case the returns are done. Pursuant to the earlier order of the court, Sheldon Korn will sign the returns along with John Bull, the accountant, and the returns will get filed. And then just to keep everybody kind of on the same page, then we're waiting for the shoe to drop from the IRS in assessing penalties because the returns were not filed on a timely basis. And again, from what I had seen, that penalty is somewhere close to $10,000 a year. We have at least 18 years. And so the expectation is that request for a penalty might come in, and then the parties would seek to get that waived. And if not waived, then we're going to have an issue as to whether or not Mr. Finling should have liability and whether he was responsible or not for filing those returns that did not get filed. I think on an immediate basis, and I talked to Mr. Nelson this morning, his suggestion was that the court maybe set a deadline for Ashley Byron to just get back to the parties and either tell us she does or doesn't have an objection with the way they're prepared, so that this doesn't just go on and on and on. I think that was a good suggestion that he had. I don't know how long Mr. Cleavorn might ask for, assuming the court were inclined to put a deadline on. My guess is whatever he'd ask for would be most likely reasonable, but we'd like to just get them get them filed and get that process moving. And that's where that's at. And other than that, I think that was the main reason for the status conference. And I guess the court could give us a new status conference with the same sort of language as before that maybe we'd actually jump onto, and that is maybe cancel it if we don't need it. And I think that's what the court's done before, and I think that would make sense.
Yep.
Okay,
And
Mr. Cleaver?
I was going to say, if I may jump in just to address, yeah, I keep hearing from my client that, you know, or again, I've reviewed them. I didn't tag any issues myself. My client just wanted to talk with their accountant, kind of what's the personal impact to me. I don't have the official green light as right now, but I kept getting told, oh, it'll be this week, it'll be end of this week. I've been told that the last few weeks. And so really any day now, I expect to have the green light, but I don't have it at this juncture. So I'd anticipate being able to provide that, you know, any day now, but I keep kind of putting a bug in my client's ear in that regard. And so, yep, I know we will, again, work to get that as soon as I have that.
Okay. Anyone else want to jump in?
Judge, it might be helpful, rather than awaiting approval or disapproval from Mr. Cleveland's client, that to set a deadline for filing a motion by her with respect to objections, because everybody has been on board with respect to the agreement that the returns need to be filed. And if she has an objection, we should make it an affirmative obligation on her part to do something about it rather than awaiting her consent, because then we're just held hostage to her decision. So my suggestion would be that the court set a 14-day deadline for her to file objections to the returns, as for whatever reason that her accountant thinks they're inaccurate or there's a mistake or something that needs to be rectified. And if she doesn't do so within the 14 days, that the returns be filed. And then I can address the next date for, I'd like to address the next date for whatever status conference we might have. I've been on the phone a lot with the IRS over the last week, and I don't expect that even if the returns are filed now, that we're going to hear anything for 6 months. It's been pretty clear to me that the section chief that I spoke with lost 40% of his lawyers, and that is going to be a substantial amount of time before anything comes back from the IRS. And if something comes back from the IRS, we know that the court will be amenable to setting an earlier date. So unless you think there's some benefit of us coming back to tell you that we still haven't heard from the IRS, I might suggest a 180-day date for a status conference, and I'll answer any other questions the court may have.
Okay. All right. I think that's a good suggestion. So in terms of the status conference for going forward, the court will set that next date for 6 months. I agree with Mr. Findling to the extent that anybody needs a hearing sooner than that. I can absolutely make time sooner than that. And then Mr. Cleavorn, I think that's a good suggestion too, setting a date certain for your client. So I'm going to, rather than 14 days, I'm going to make it 30 days. So if your client has any objection, that would need to be filed within 30 days, and then we'll address that in due course. If no objection is filed, or if Mr. Cleavorn gets consent from his client sooner than that, then the parties can move forward with getting those filed. And I will put that into the status conference order, along with the other things we've discussed here today. And then the parties will also get the notice of the date and time of that next status conference in about 6 months. Anything else that I can address for anyone while we're on the record here today?
Not from the
All right,
receiver.
great. Sounds good. Thank you for your time, everyone. That's all we have for today, and everybody's free to disconnect at this time.
Thank you.
Thank you, Your Honor.
Thank you very much, Your Honor.
That concludes our morning docket. The court will be in recess.